Hello everyone, welcome to the Business Law Final Cram session. Let's jump into it. Okay, so civil law versus criminal law. So civil law is a dispute between individuals or businesses. The remedy would be money damages or court order. Okay, you need burden of proof, which would be the preponderance of evidence, which is greater than 50%. Next, we have criminal law. Criminal law is a crime against society. Punishment is jail or fines. And the burden of proof for this one is beyond a reasonable doubt. Okay, burden of proof basically means like how much proof do you have to convict someone? So, court and procedure basics. So, what's a jurisdiction? A jurisdiction is a court's authority to hear a case. What's interstate commerce? Interstate commerce is a business between states. What's intrastate commerce? Intrastate commerce is business within a state. What's the Commerce Clause? The Commerce Clause is basically Congress being able to regulate interstate commerce. Okay, now what's due process? Due process basically is saying that the government must act fairly and give everyone the right to a fair trial. Yeah. Okay, so let's go into the litigation steps. So first, a complaint is filed. Then, service of process happens. This is where the defendant gets notified. Then we have an answer. Next is a discovery, where evidence is gathered by both sides. And next we have the trial, or the summary judgment. Summary judgment is a motion that gets passed when there's no disputing of key material facts or evidence. Okay. Next we have the judgment, and lastly we have the writ of execution. Basically, this is the collection of money whenever the losing party fails to pay up, and then they refuse to. So the defendant, so for the winning party would go to the court and then ask them to force the losing party to pay, and the court would give the police the power to collect whatever, like property or assets, to pay up the winning party. Alright, next we have contract law. This is a high priority, high stakes. So it's important you understand it. So there's 5 elements of a valid contract. We have the offer, the acceptance, the consideration, the capacity, and the legality. The offer, acceptance, consideration, capacity, and legality. Some important terms for you to remember are void, which means no legal effect; voidable, which means can be cancelled by one party; bilateral, which means promise for promise; unilateral, which means promise for action; express, which means stated clearly; implied, which means shown by conduct; and the privity of contract. This is basically the direct relationship between parties in a contract. What are the contract defenses? The contract defenses are duress, which could be threat, so if someone forced you to do something, that would be duress. Next we have fraudulent misrepresentation. Then we have the mistake, and we have the lack of capacity. Okay, let's go into tort law. So intentional torts versus unintentional torts. Intentional torts, as in the name, require intent, and unintentional torts are usually a result of negligence. Okay, so intentional torts. Examples of them are assault, which is a threat; battery, which are harmful contact; false imprisonment; and defamation. Defamation could be written. If it's written, it's libel, and it could be spoken. If it's spoken, it's called slander. Okay, so negligence. In order for something to qualify as negligence, it has to fall under these four, and all four have to actually happen. So what are these four? Memorize them. So we have the duty, we have the breach, we have the causation, and we have damages. The burden is that the plaintiff must prove all four. Okay, let's move on to strict and product liability. So strict liability. Strict liability says that there's no need to prove negligence, and it's used for dangerous activities and defective products. For example, like runaway animals. Okay, strict product liability. You must prove these six. If one of them isn't proven, then it won't fall under strict product liability. The product was defective, the seller was in the business of selling, the product was unreasonably dangerous, the physical injury occurred, the defect caused injury, and no major alteration happened after sale. So like it wasn't a billion years old, Yeah. Okay. So types of defects. We could have a manufacturing defect, a design defect, or a failure to warn. So like no labels. Okay. And if it's negligence, then privity of contract is not required. Okay. So let's go into criminal law. For criminal law, you need actus reus and mens rea. Actus reus is a guilty act, and mens rea is a guilty mind. So types of crime. We have a felony, which is serious crime, the highest degree. We have a misdemeanor, which is less serious, and we have a white-collar crime, which is a non-violent financial crime. Okay, so examples of crimes are embezzlement and money laundering. Okay, so criminal defenses, what are they? We have self-defense, necessity, insanity, duress, and entrapment. Okay, so remember your constitutional rights. This will be very important. So we have the Fourth Amendment, which protects us against unreasonable searches, and it requires probable cause. We have the Fifth Amendment, which says that we have the right to remain silent, and then we can't like self-incriminate ourselves, and no double jeopardy. We have the Sixth Amendment, which guarantees us a speedy public trial with jury and the right to attorney. And we have the 14th Amendment, which guarantees due process and equal protection. Okay, let's go into the exclusionary rule. The exclusionary rule basically says that illegal evidence is not admissible in court. Okay, we're almost in the home stretch. So, internet law. Internet law, remember these three. Cyber squatting, which means bad faith domain registration. Trademark dilution, which means the weakening of famous trademark. And then the social media posts can be used as court evidence. Okay, so the most tested comparisons will definitely be civil versus criminal burden, negligence versus strict liability, manufacturing versus design defect, void versus voidable contract, interstate and intrastate commerce. But if you only memorize 8 things, memorize these 8. The 5 contract elements, the 4 negligence elements, civil versus criminal burden, strict product liability elements, actus reus and mens rea, 4th, 5th, 6th, and 14th Amendment, the Commerce Clause, and product defect types. Thank you, and have a great night.